File. Jack.
Busy afternoon, Wolf. And we got another story we're working on here, and the deadline is coming perhaps as early as Friday. Some people are still not satisfied with the Bush administration's deal with top Senate Republicans over the treatment of detainees. Former diplomats, retired federal judges, lawyers, Republican and Democratic leaders on the Senate Judiciary Committee all oppose a provision in this compromise bill, it's still in there, that would bar detainees from challenging their detentions or the condition of their treatment in court. A Republican lawyer who served in President Reagan's Justice Department is urging Congress to slow down in their rush to set these new rules before the election. But caution flags and questions be damned. Senate Majority Leader Bill Frist has indicated he wants to bring this to a vote before senators adjourn on Friday. Don't kid yourself. The real reason there's such urgency attached to getting this thing passed is this. The bill contains a sort of get-out-of-jail-free card for anyone who may have violated the Geneva Conventions in the handling of detainees dating back to the start of the War on Terror. Under the National War Crimes Act, any violation of the Geneva Convention is a felony. And Republicans are afraid that if they should lose control of either chamber of Congress in the upcoming elections, well, that get-out-of-jail-free card might be a little tougher to get a hold of. Here's the question. What kind of standard would the U.S. set if it does not allow detainees to challenge their detention in U.S. courts? Email your thoughts to CafertyFile@CNN.com or go to CNN.com/CafertyFile. Wolf?
Good question, Jack. Thanks very much. Let's check back with Jack. He's got the Caferty File. Jack?
Thanks, Wolf. The question this hour, what kind of standard would the United States set if it didn't allow detainees to challenge their detention in U.S. courts? Dan in Aurora, Illinois, it would be setting a bad one. We don't have to give them all the rights that we have, but we at least get them tried in our courts. It's longer than using military tribunals, but the right thing is not the convenient thing usually. We should try to appear as the better people in this conflict. William writes, if we don't allow detainees to challenge their detention in courts, a principle of law dating back to the Magna Carta will have been removed from the American legal system. In addition, the War on Terror will have wrought upon Americans what the Cold War could not, the conversion of our ideological principles to those previously held by communists and fascist dictators. Ian in Charleston, South Carolina, we're beyond using the word standards when it comes to this administration's policies. We checked those at the door to Abu Ghraib, and we've been spiraling downward ever since. David in Texas, not giving detainees full rights to defend themselves, sets the same standard as that in states with stellar judicial standards like Iran and North Korea. And Benji in Laredo, Texas, standards? Bush doesn't care about standards, and neither does the religious right. Otherwise, they would see that torture has become and should not be a family value. What happened to the family values party? Sex is bad, torture's okay? That's more like the devil than Jesus. If you didn't see your email here, you can go to